Start off with a example of how to do estate planning. And since Anderson Business Advisors is based out of Las Vegas, I used two popular or well-known Las Vegas residents. We've got Howard Hughes, who died in 1976, and ultimately he was discovered to not have a will or any type of estate planning done. And it took from 1976 to 2010 to probate his estate. During that time, there were teams and teams of attorneys that made their entire living off of his estate. And in the end, most of it went to either the government as part of taxes or went to the lawyers for with all of their fees. Compare that to Frank Sinatra, right? He died with both a will and a trust. Now, we know what happened to the assets that were distributed through his will, because that did have to go through probate. But the assets that were in a trust, we have no idea where they went, who was the beneficiaries, who got what. We don't know because it wasn't public information. And so you have these two different, major players in the Las Vegas area at the time, and had very different outcomes because one did planning and did planning with a trust, and the other one just kind of lived his life and lived large, never actually thought about these things. So let's talk about what are the different types of estate planning. The first level is what we call intestate, meaning there is no planning done. You don't have a will, you don't have a trust, you didn't do anything. This is the worst type of planning that you can do. You have to go through probate, and we'll talk about what probate is here in just a minute. You have no tax planning. You have no control over how your distributions are going to go. The state actually determines who gets your assets after you pass away, and it's all public information. A will is what most people are familiar with, right? And with a will, when you pass away, all it does is gives instructions to a probate court on what to do with your assets. So you still have to go through probate when you have a will. Now, a lot of people will come to me and they'll say, hey, I've got this. It says will at the top, but it also says that it's a trust. That's what we call a testamentary trust. It means the will creates a trust upon your passing that still has to be probated. And a lot of attorneys will push these because they get more fees that way. The beneficiary designations, this would be like on a life insurance policy that you have or a retirement account that you set up. When you set those up, you name who you want to get that payout after you pass away. That's a beneficiary designation. Those do avoid probate. And so they can be useful under certain circumstances, but we'll talk about why maybe certain circumstances they're not quite as useful as you may think. Third one is joint tenancy with the survivorship. You have this on a piece of property that you own with a spouse or someone else. That means when one owner dies, other owners gain full ownership of that asset. They continue on owning it. And that does avoid probate, but there are some pitfalls that go along with joint ownership. So we'll talk about those. And then finally, trust, more specifically, a revocable living trust that's typically used in estate planning. That avoids probate, allows you to have tax planning, allows you to have privacy, which is very important, and allows you to have full control over the distributions. So let's talk about probate. What is probate? Simple, if you look at the word and the root of it, it just simply means to prove. And if you want to summarize it down to one concept, that concept is a dead person cannot sign their own name. Okay, very simple. Why does that matter? Let's say you've got a piece of property and you're the owner on that property on deed. In order to sell that property or to transfer it to someone else, you have to sign a new deed that transfers the property. Well, if you're dead, no one can sign it. And so the government and the states have come up with this system to allow someone who is not dead, someone else, a representative, to sign on behalf of a person. That is probate. So it can be a very complicated system. Basic idea is you submit to the court to open the probate. You get what's called a personal representative appointed. That's the executrix. And now we just call it personal representative. And then they are responsible for, inventorying assets, contacting debtors, contacting heirs, submitting paperwork to the court. If any of you have been through this process, it is a pain. And typically, in order to do it, you have to go and hire an attorney. And so that's why when I talked about those wills that create a trust, a lot of attorneys will push those because they'll collect a fee initially when you create the documents. So if you create a will, they might not charge you a whole lot. It's usually pretty cheap. But they know after you pass away that your family is going to come back to them to do the probate work. And they're going to charge, minimum probate fees here in Utah are around $5,000. That's for a very simple, very small estate. It balloons from there. It can easily be $10,000, $20,000, even if you just don't have that much stuff. So it can be very expensive. It can be very time consuming. If you're in California, good luck getting through probate in less than 2 years. And during that time, all of your assets are tied up in that probate. You can't sell them. You can't transfer them. They're just sitting there. And so it's a very painful process for your family to go through. So if we can avoid it, we should. Now, there are times that probate can be useful, but they're very, very limited. We don't necessarily have to go into that. Beneficiary designations, right? And this is the one where we talked about with life insurance or retirement accounts. Usually you'll have a beneficiary designated who's going to get paid out upon your passing. Now, you can use beneficiary designations for your entire estate plan, depending on your state, but most states will allow you to do a beneficiary designation on a deed, so on property you own. You can do a beneficiary designation on a bank account. It's called a POD, or a payable on death. You can do it on your retirement accounts, life insurance. You can also even do it on a business, although it's a little bit more complicated to do that. So I have had people that come to me and they say, well, I've got beneficiary designations on everything, so I don't need a trust, right? I've got it so I can avoid probate, right? They'll avoid probate for you. The problem is, what I've seen when people use this strategy is once they pass away, the kids all go and collect the funds, the money, the assets, and they take direct ownership of it. They're the designated beneficiary, right? And after someone passes away, there's still debts, there's still taxes that have to be paid. But if everybody's got their piece of it, nobody wants to give up what they've got to go and pay those debts and those taxes. So I have seen it where, the taxes were kind of ignored, and the IRS, they're not the most efficient government agency. I don't know if there is such thing as an efficient government agency, but they took years, right, to finally get around to saying, hey, you actually owed us taxes. And they can follow the money directly to the beneficiaries. Well, during that time, you have penalties, you have interest and fees, and they all added up, basically went in and just wiped out all the beneficiaries. So the problem with using just beneficiary designations is there isn't a centralized management like you would have with a trust. So this is good for certain things, like I said, life insurance, retirement accounts, but usually I wouldn't use it as your sole method of estate planning. Another method is joint tenancy. I've even seen this used in my own family. The problem with joint tenancy is if you put your kid on the deed as a joint tenant with rights of survivorship, yes, you will avoid probate. But while you're alive, that kid is the owner on your property. If something happens to that kid, the lawyer I used to work with used to say, kids are like yogurt. You never know when it's going to go bad. If they have a creditor coming after them, they can go after your home that you put up that kid on as a joint tenant. So I don't really like joint tenancy. Also, you lose out on some tax savings because you don't get a full step up in basis. It has a lot of different pitfalls, and so why not just use a trust that's going to avoid probate and avoid all the pitfalls that a joint tenancy has? So with a living trust, we avoid probate, right? And how does that avoid probate? With a trust, you create the trust, which is just a document that you sign, and then you go and you transfer assets into the name of that trust. So if you've got a piece of real estate, you're going to deed it into the trust. If you got a business, you assign the interest of that business into the trust. Something like bank accounts, life insurance, you're going to use a beneficiary designation, but you're going to list the trust as that beneficiary. And so everything goes into this trust. Now, within the trust, you have trustees and you have beneficiaries. The trustees control the assets. They manage it, they sign for the trust, they decide how assets are invested within the trust, and they make distributions from the trust. The beneficiaries are the ones who can receive the distributions, the benefits of the assets in the trust. And so with a living revocable trust, originally you are the trustee and you are the beneficiary. So you control everything, you get the benefit of it. You can do whatever you want with these assets in the trust. You can go down to Vegas, you can blow everything. That's fine. There's nothing wrong with that. But when you pass away, the owner of the asset didn't pass away. Because remember, when we talked about probate, it's all about signatures. And so with the trust, the person who signs on behalf of the trust is the trustee. And we can swap out who that trustee is. So when you pass away, you name a successor trustee. They automatically step in, have control over the assets, it can sign on behalf of the trust. All they have to do is they file a document. So if it's a property that you had in the trust, they file an affidavit of successor trustee, which is just a one-page document that they fill out and sign. And immediately they have control over that asset. They don't have to go through probate. They don't have to disclose who the beneficiaries are. This is all done privately. A trust is not public information. The only thing that may be public is the name of the trust. But other than that, no one's going to know about it or how it's administered. So we get around probate because we're just swapping out different people for the different roles. So you're the trustee and the beneficiary while you're alive. You name a new trustee who takes over after you pass away, and you name new beneficiaries. And you get to determine how the assets are going to be going to those beneficiaries, at certain ages, under what terms you want those to be distributed. So you get to have control over that. And then also for tax planning, we can talk about that, but there are ways of reducing estate taxes by using a living trust that you may not be able to do with other types of estate planning. Okay. I got a question about titling, importance of titling. It is very important that the assets get titled or transferred into the trust while you're alive. Let me give you just a quick example. we're going to use Don as our subject here. So Don has a bank account, and he is a very nice guy, and he creates a will, and it says John gets my bank account when I pass away, right? And then he does something even nicer. He dies, right? I go down to the bank, I've got a copy of his will, and I say, here, bank, right here, it says on here that I get the bank account. What's the bank? They're going to turn me around and say, go get a court order from the probate court, prove that this was his final will, everything was done correctly, he doesn't have creditors, and then come back with that court order from the probate court, and then we'll let you into the bank account, right? Now, let's say he did a trust instead, but he didn't actually let the bank know that he created this trust or set up the trust as a POD or title the account in the name of the trust. He just has the trust and the account's left in his personal name. If I go down to the bank after he passed away and I say, look, here's a trust, and it says I get the bank account, the bank's going to turn me around and say, go back to the probate court, get a court order, because we don't know if this was his last trust that he made. He could have changed it. Go and prove, make sure everything's good on the probate side, and then come back and we will let you into the account, right? So that's a trust without titling. Now, if Don actually set up the account in the name of the trust or set up the trust as a beneficiary on the account after he passed away, all I would have to do is go into the bank, say, here's the trust, and they go back on their records and they say, yep, that is the same trust we have on our records that's supposed to be controlling this account. I need ID, copy of death certificate, affidavit of successor trustee, and then I'm into the account. So if you don't title the assets into a trust, it doesn't really avoid probate. You've got to get the assets actually titled. So one thing that a lot of people will do is they get the will because they don't want to go through the work of transferring assets, into a trust. It's more work than they want to do. But the work to do transfer assets into the trust is 100 times easier than dealing with probate. So a little bit of work now saves a lot of work later, right? An ounce of prevention is worth a pound of cure, basically. Okay. So what kind of different trusts are there? You probably heard of, land trusts, revocable trusts, inter vivos trusts. You may have heard spendthrift trusts or asset protection trusts. There's a lot of different terms out there about what kind of trusts there are. To be honest with you, all of them are marketing terms. There are only two types of trusts. There is a revocable trust and there is an irrevocable trust. And the only difference between those two is with the revocable trust, you can change it during your lifetime. So you can create the trust, and then if you decide, I don't like my kid anymore, the grandkids are cuter, you can change who the beneficiary is. With an irrevocable trust, once you create it, you cannot change the terms of the trust. That's the only difference. When you hear all these different terms like charitable trust, spendthrift trust, slats, grats, idiots, there's all sorts of acronyms out there. It's not describing a totally different kind of trust. It's just describing the provisions or the terms that may be in that trust or the strategy that's used for that particular trust. So just understand there's revocable and there's irrevocable. Revocable trust, 90, 99, 95% of people will be just fine with a revocable trust. You don't typically need to go into the irrevocable trust route unless you have a taxable estate, which right now for federal taxes, estate taxes is 13.6 million for an individual, about 27 million for a married couple. If your net worth is under that amount, you don't need to worry about it. Okay. The other thing that irrevocable trusts are used for is for asset protection. That's usually under limited circumstances where you have a very high liability, like a doctor or architect, or I've done these for restaurant owners, tow truck drivers. People that have a very high liability and they have other assets that they want to protect. That's the other case where you might have an irrevocable trust that's set up. And it's always in connection with a living trust. So I don't set up just an irrevocable trust typically on its own. Usually I'll have a living revocable trust, and then if we need to, we'll have an irrevocable trust in addition to the revocable trust. Okay. So we kind of talked about grantors, trustees, beneficiaries. Those are different parties of a trust. So what kind of control can you have over the distribution, right? You got to be careful here. Some people want to have all the control. That's not really going to happen. But you can have control over things like when distributions are made. You can create incentives for certain types of activities that you want the beneficiaries to do. So you can say, you know, hey, upon your graduation of college, you'll get this distribution. If you don't graduate from college, you're not getting that distribution. So things like that, where you can incentivize the beneficiaries to do certain things. So it gives you a lot of flexibility as far as how you want that to look and what you want it to do. But just understand you're not going to be controlling your kids' lives from the grave. Okay. I have a lot of people that think, oh, if I set this trust up just right, you know, my 40-year-old son who's a drug addict will all of a sudden stop being a drug addict because of what I wrote in this trust. That's not going to happen, right? That's your son's choice. We can set it up so that it gives him incentive to do it, but ultimately he gets to make his own life choices. So we talked about estate taxes briefly. The federal one is 13.1 for an individual, 27 million for a married couple. Some states also have an estate tax. So if you live in one of the states, you need to keep that in mind. There are ways of eliminating that tax, but you got to be careful because eliminating the tax just outright can have unintended other tax consequences. So don't just think, oh, I'm going to get rid of this tax, because it can actually be very easy to, there are a lot of loopholes basically to get around it. But make sure you're working with someone who actually understands estate taxes and kind of steer you in a certain direction, because just doing it, just eliminating the estate tax, like I said, can have other consequences that may not be so good. You also have states that have an inheritance tax. This is different than a estate tax. So you've got Nebraska, Iowa, Pennsylvania, New Jersey, and Maryland have an inheritance tax. This is paid by so an estate tax is paid by the trust or the estate of the person when they pass away. So if I was worth $50 million and I died, from that $50 million that I had, I'd have to pay the government a certain amount for the estate tax. An inheritance tax is paid by the person who receives the assets. So if I'm, you know, and those usually don't have minimum requirements. It's just a percent tax, and it's often based off of the relationship. So if it's going to a spouse, usually it's not applied, but if it's going to a kid, you pay a certain percentage. If it's going to a more distant relative, you pay a higher percentage. If it's a friend, you go to a different percentage. So it can be kind of crazy, but it's based off of where the person who's receiving it lives and how much they're receiving. So if you live in a state that doesn't have an estate tax, but you have a kid who lives in one of these states that has an inheritance tax, they may have to pay taxes when they receive an inheritance from you through the trust. Okay. Now, a trust on its own is usually not enough. There's what we call ancillary documents that you're going to add along with the trust. So we have a pour over will. Now, this is a will that just simply states anything that got left out of my trust when I die goes into my trust. It's just a catch-all. So if for some reason, you had a piece of property, you forgot about it and left it in your personal name instead of titling it into the trust, when you die, yes, that's going to have to be probated, but the pour over will is going to direct the probate court to transfer it into your trust, and then it'll be distributed under the terms of the trust. So we always do a pour over will just as a backup, just a catch-all in case something got forgotten. We also have powers of attorney. Now, powers of attorney for financial and medical, typically these kick in upon incapacitation. So if you're in a coma, can't make decisions on your own, we've got someone named under the power of attorney who will step in and manage either your financial affairs or your medical affairs, right? So you don't end up like Britney Spears. If she had done a power of attorney, she wouldn't have been in the situation she was. There is one exception to this as far as the only kicking in upon incapacitation. That is if you live in the state of Florida. Florida is special. And because you have that privilege of living in that state, as soon as you sign a power of attorney in Florida, it is immediate, meaning the person you've named as your agent who has power can immediately make decisions on your behalf without your consent. So you got to be careful with these in Florida. Everywhere else, we can just create the document so that it only comes into power when you are incapacitated. We have physician's directives. This is also called an advanced healthcare directive or a living will. This allows you to deny care that you don't want to receive at the end of life. So things like a DNR, do not resuscitate, or you don't want a feeding tube, or any of those things that you want to refuse care, that would be in a physician's directive. Declaration of guardian. This is if you have minor children or if you have an adult child that you have a guardianship over. You will say within your documents, I want this person or this couple to take care of my kids until they reach the age of 18. This is very important. If you do not decide this, the government decides this for you. And in the situations that I have dealt with and where there's fighting, guardianship is by far the worst, right? Because you're not arguing over money or the house or anything. They're arguing over a kid, and it's not a good situation to be in. So if you can name, okay, I want this person to be my guardian. If they can't do it, then I want this person to be my guardian. 99% of the time, the court is going to go with you, unless there is a very good reason why that person shouldn't be the guardian. If they're in a hospital in a coma, the court's not going to name them as guardian. But otherwise, if you direct the court to say, I want this person to be my guardian, they will honor that. And a guardianship always has to be appointed by a court. And then you have a schedule of gifts. This is for like personal assets. So what we call the dollies and the doilies. A lot of times when families fight, it's not over money. I can take $1 and I can split it up, between the 4 kids. That's easy to do. I can't take mom's wedding ring and split that in 4. And so in our trust that we create, we have a schedule, or we call it a personal property memorandum, where you can list out personal items and then designate who you want it to go to. By doing this, you're going to eliminate most of the fighting after you're passed away between your kids. If your kids are upset because, Johnny got the sewing machine and Mary got the shotgun, they can trade, or they can go jump up and down on your grave, but, the kids aren't mad at each other because they didn't take it from each other. They can be mad at you and you don't care. And then final instructions, what do you want to happen as far as your burial? Do you want to be buried? Do you want to be cremated? Do you want your body donated? Do you want to be an organ donor? Do you not? These types of things you would write into the final instructions. Now, it's important that you don't just write it down and then just go hide it, that you involve your family in these decisions, because ultimately it is up to your family as to your what to do with you, to do with your final remains. And so if you want something in particular or unique, you need to make sure and let them know, because a lot of times what happens is you die, the family comes in, takes you to the mortuary, get you embalmed, and then a week after the funeral, they pull out the documents and read, oh, I actually want my body donated to science. Little late for that. So do make sure that you include your family in these discussions and that they're aware of what your wishes are. Okay, let's take some more questions. There's just a couple more slides, but they're dealing with more theoretical type of stuff. Let's see. Yeah, so someone was talking about how they are going through probate with their uncle he didn't have a will or trust, and it is just taking forever to administer that. So we do beneficiary designations, only one child. The child takes care of the taxes, then they can stick with that strategy. Ultimately, if you name one child as the beneficiary, that asset or that money that goes to them is theirs. They don't have to give it to your other children. And even with one child, I've seen them ignore the taxes and ignore the debts, because they don't think they technically have to be responsible for that. Now, if you have a child who is pretty responsible for it, yeah, that could work out. I have had situations where there wasn't much assets and I just told them to do beneficiary designations. But if you've got a lot of assets, businesses, properties, bank accounts, brokerage accounts, it's a lot easier to manage that through a trust than to try and gather everything through a beneficiary designations. If no one can see the trust, how can people verify the contents, say from the debtor? When you, like, for example, with a bank, when you go into the bank and set up the account with the trust as a POD, they actually will take information from that trust so that when your successor trustee comes in with the documents, they can compare to make sure it is still the same document as what was originally given to them. Now, it's not made public in any way, but the bank will take some information from it to make sure it's correct. What's the difference between assigning ownership to a trust versus naming the trust as a beneficiary? If you actually transfer it into the trust is the owner. Whenever you're signing on behalf of that asset, you have to sign as trustee. If you just assign the trust as the beneficiary, the asset or the account stays with you personally, and you just sign your personal name, and then it only goes into the trust after you pass away. Typically with bank accounts and brokerage accounts, we use the beneficiary designation, not because there's an advantage to it, but because the banks are easier to work with in that situation. If you go into the bank and say, hey, I want to transfer my accounts into the name of the trust, a lot of times they're going to try and make you create a whole new account. And then you've got to change over your direct deposit and all your bill pays and everything that comes out of that account automatically, and get new checks and all this different things. Whereas if you just tell them, hey, set up my trust as the beneficiary, then the account stays the same, and you don't have to go through all that. And the outcome is exactly the same. You avoid probate, the trust is in control after you pass away, everything's good. Do you have to file with a trust with the state? Nope. A trust is not filed with the state in any way. So you create the document, you title assets into the name of the trust, but the actual documents you keep. Now you want to make sure that your successor trustee knows about it and that you let them know where the documents are so that if something happens to you, they can go and get them. And so a lot of times people will think, oh, I've got to protect these and lock them, in a safe deposit box or something like that. It's not always the best idea. I've had clients that they put their trust in a safe deposit box and didn't tell anybody. When they die, nobody knows what to do. And then just having to go through probate to get into the safe deposit box. And then once they get in the safe deposit box, then they realize, oh, there's actually documents. So my rule of thumb is you want to keep it safe so you don't lose it, but not so secure that nobody can find it. Can a business bank account have the trust as a beneficiary? No. Typically, they won't set up a beneficiary on a business bank account because the business doesn't have a life, right? The business isn't going to technically die someday. So what you do is you assign the interest or the ownership of the business into the trust. So the trust now owns the business, and then the business owns the account. So that would take care of that. Settler is the same as a grantor. Sometimes they're called heirs, grantors, trustors. It's all the same.
John, is it okay
How
if
does
I
an
help
exam?
you with
Yeah,
some of these questions?
sure.
Okay. Diane's asking, how does the executor get an affidavit of successor trustee form?
Um, they're usually state specific, so each state usually will have their own form for that. Honestly, I just Google it, and I can find usually a form on Google for it. They're pretty simple. So
Hey, John, what do you think about giving with my parents, it was really easy. There were five kids. Each one of us had a copy of the trust 10 years before Dad needed it. Um, I know that doesn't work in all situations, but there was no surprise Hollywood kind of crap. It was just we knew what we were doing, and I don't know, it just worked really well for our little family. Is that common?
yeah, when people are older and they have kids who are stable and um, that's pretty common where you want to include the kids in that conversation so that everybody's on the same page and there's no surprises when mom and dad pass away. It's a little more difficult to do when you have younger children, right? You might
Right.
have a different trustee, another family member or friend who's going to be the successor trustee. You may give them some information, but you don't necessarily want to give them everything at that time. So it evolves over your lifetime. How much you're including other people in there.
A lot of the problems that I've seen is somebody has a copy of the trust and won't share it with the other siblings, and they're the only ones that have it, and it takes quite a bit of legal maneuvering to get a copy of the trust, and by then the assets could very well be gone. Your thoughts on that?
Um, Name a good trustee. It really is. The trustee that you name as your successor trustee after you pass away is the most important thing you will do in that trust, not the distributions. Everybody's focused on the distributions, right? How do I want to make these distributions to my kids and encourage them to do different things? Um, the trustee is the most important thing that you're going to name in that document. They
What do you
will
think
either
about
make it
naming
or break it.
co-trustees?
Co-trustees work well if you're not too sure about the trustee's ability to manage things, because then you've got a check and a balance, right? Two people are working together and making sure that they're doing what they're supposed to. It does complicate it a little bit more. So they have to agree and come to a decision on what's going to happen. So I don't mind co-trustees. Um, I prefer it in most situations, but there's some people that don't even have, they're not even sure of who they would name as a trustee at all. And you may just have one person that you trust, and that's who your trustee is going to be.
Okay.
So,
Cindy is saying mom and dad died, they had a revocable trust. Can mom change things in the trust?
it depends on the terms of the trust. Some trusts after one spouse passes away doesn't allow for changes. Some of them do. So we'd have to look at the trust documents, look at the wording, and see what it allows for. If it doesn't technically allow for changes to be made, there are ways of making changes to it. You just have to get the consent of all the other potential beneficiaries. So if mom wants to change the trust and the kids are the beneficiaries after her, you would just have to have the signatures of all the other kids agreeing to the changes.
And you'd also make sure that all the assets were properly funded in the trust and
Right.
make sure that the trust really can control it. Often I see the trust was created, but it was the assets were never funded into the trust anyway, and so it really the trust can only control that which it owns, and if you didn't put the assets in, trust can't control it.
Yeah, if the assets aren't even in the trust, technically your mom could go make a new trust, put the
It's
assets into that one if she wanted to. Um, but yeah, you'd have to look at the terms of the trust to see if it can be changed after one spouse passes away.
okay. Kay is asking, can you word an irrevocable trust to maintain the right to change beneficiaries?
To a certain extent, you can, but it's going to be fairly limited as to, I mean, technically you can have the trustee determine who the beneficiaries are if you wanted,
Okay.
but then you're giving all the power to the trustee, and you better hope they're going to do what they're supposed to do. That's not a strategy I would advise. But
Okay. All right, good. Beverly is saying new law Biden 32922 IRS no longer recognizes an irrevocable trust will be fully taxed to the beneficiary. Your thoughts on that?
so are you talking about the estate tax? There was a clarification as to the step up in basis for irrevocable trust as far as estate tax planning goes. And there was kind of a gray area where if you put assets into an irrevocable trust and it wasn't subject to the estate tax, did the assets still get a step up in basis upon the passing of the grantor? And some people were arguing yes, it did, and some people were arguing no, it didn't. And the IRS finally came out and said, no, you don't get a step up in basis. But that's only dealing with irrevocable trusts that are set up for estate tax planning specifically. And I've always been in the camp that no, it shouldn't get a step up in basis. Because once
Right.
you understand why you get a step up in basis, it's pretty clear that, yeah, those assets should never have gotten a step up in basis.
And
So it
Beverly,
wasn't
that
necessarily
same
a big change.
Beverly, that same issue kind of was resolved with S corporations, real estate within S corporations last year with an IRS ruling that if your S corporation owns real estate, you're not gonna the kids aren't gonna get a step up in basis, and we've never recommended you have put real estate in an S corporation anyway. So
Yeah.
yep. Okay. Anonymous. I love Anonymous. I don't know who you are, but you ask a lot of questions. It sounds like the trust is the direction. However, what are the things we need to know about? I mean, what is, what I mean is that I didn't know once we set up the trust, we cannot refinance our property.
You can refinance the property. If it's a revocable trust, it just depends on the lender that you're working with. Um, but a lot of times you may need to get an attorney opinion letter from the attorney who drafted the trust saying that you have the power to refinance it, or sometimes you have to deed it out of the trust, refinance it, and then once you've finished the refinancing, you deed it right back into the trust. So there
Right.
are ways of refinancing even with a trust.
So let's say you put the property back in your name. The, the bank won't let you do it, so you put the property back in your name. You file a quit claim deed, get it back in your name, refinance it, and then transfer it into the trust. The bank can't prohibit you from doing that. They can't call the loan due. There's a 1983, I don't know, 84 Garn-St. Germain Act that prohibits them from doing that. So they shouldn't have a problem with it. But if they do, transfer it into your name, get the refinancing. It shouldn't be that big of a problem to do that.
Yeah.
Sandy is saying California doesn't have an estate tax. Does it mean I don't have to pay any tax once after I die? Well, you're dead, so you're not going to be paying the tax anyway. But California does not have an additional estate tax, nor do they have an inheritance tax. So the only thing you'd be paying would be whatever the federal limits are. Is that
Yeah.
anything to add?
Well, so there are some taxes that are still due, right? So let's say you die in July, right? So technically you're not filing the tax return until April of the next year. But your trust will be, or your successor trustee will be filing that tax return, but they have to file a 1040 for all the income from January to July. That's still owed. And then after you passed away, then the trust takes over. You file a 1041, which is a trust tax return for the income from July till December. So yes, you don't owe estate taxes, but after someone passes away, usually there's still income taxes that are still owed from the year while they were still alive.
Okay. Yeah, really good. Thank you. All right. Can the beneficiary, and I assume we're saying the successor trustee, um, be a foreign national, or do they have to have a social security number?
So the beneficiary and the trustee technically can be outside of the country, be a foreign national. Uh, for the beneficiary, that's not too big of a deal. That's fine. There's some logistics issues you have to get through to if you're going to be transferring money to other countries. Um, Having the successor trustee out of the country, although that is legal, it does create other issues. Um, a lot of times the trustee needs to be present for certain things, for signing documents. Um, they can hire a professional help. So sometimes if you have no options here in the United States, I have clients like this. They came to the United States. Everybody else they know is back in a different country. We'll name someone outside the country as the successor trustee, but their first responsibility is to go and hire someone in the United States to act as their proxy here in the United States. So typically it's easier if you have someone here in the United States, but if you have no other options, technically you can name a trustee outside the United States who's going to direct a proxy here in the United States.
Okay. Now that would be different if we were asking about the grantors were not citizens. Then you would need Q dot provisions and that complicate, but that wasn't the question, right?
Yeah, for foreign nationals trying to create a trust here in the United States creates a whole lot of issues, tax issues.
Okay. Yeah,
Like
we're not
if
doing that tonight.
if you're in like Canada, I don't even do it. You're
Okay.
gonna get hit so hard with taxes that yeah, it's really difficult to do that type of planning.
Okay, great. Um, Andy, if you have a trust and your kids are trustees, do you have to pay inheritance taxes? I live in Florida and it has no state tax.
Depends on where your kids live. If
Yeah.
they live in one of the states that has an inheritance tax, so that's what they New Nebraska, Iowa, New Jersey, Maryland, and Tennessee. I think if your kids in one of those states, then yes, they would pay inheritance taxes. But if they don't in any of those states, then no, there's no inheritance or estate taxes.
And Florida also has no estate taxes
Mhm.
additional, and they don't have inheritance taxes either. All right. Um, how many guardians can you name for your child? Oh my gosh, Annie, if these kids are teenagers, they don't want any more parents than what they already have. But um,
So
okay, how many
yeah,
guardians can your child have? And then they would be listed in succession, would they not?
correct. You can't have multiple co-guardians. Like a court, because like I said, a guardian has to be appointed by the court, and the court's not going to like divide up time between this guardian and this guardian and this guardian have to be overseeing it. The court, once they name the guardian, they want to wash their hands of this and just be done. So the only way you can have multiple guardians is if it's a married couple. If it's a married couple, they can both be named as guardians at one time, but otherwise it has to be a succession where you have this person first. If they can't do it, then we go to the other person. But you can name as many as you want in succession.
Okay, great. All right. Cost of living trust and yearly maintenance. I'm not sure what AJ is asking.
So usually there's an initial cost to set up the trust. Like ours, if you just buy a trust
Oh,
on
okay.
its own is 3,500. If you get it through a package, it's usually cheaper. Um, and the yearly maintenance, trusts don't have yearly maintenance like an LLC does. So like with an LLC, you have registered agent fees and you have state fees and all these things that you have to pay every year. Just once you sign it, just keeps going on. It's not registered, it's not filed anywhere, so you don't have yearly maintenance.
Okay. Yeah.
With our trust that we
Boy.
do, we sell them as a package where if you want to come back and amend it, we don't charge you fees for it's a lifetime trust.
Yeah. And I believe that you ought to be updating it once in a while. I was looking at my trust, and I still have minor kids, and now I now I don't. And the assets will change from time to time.
Mhm.
You'll sell a house, you'll create a new business, your vehicles will change, and so I believe at least annually. But there's no. It's not like a corporation where you have an annual filing fee, because we're not registering with the Secretary of State. We're not filing an LLC or limited partnership. It's a trust. It's a private document that the state, frankly, doesn't know about anyway. The only maintenance fees I would see would be the cost to update your file.
Yeah, and ours right now, when we sell
Schedule
a
of
trust, it's all
assets.
included,
Yeah.
right? It's so you don't have extra fees once you initially purchase it.
Can you have multiple trusts, or is it better to just have one trust?
You can have multiple trusts. It depends on your circumstances, but for estate planning, most people one trust will work just fine.
I've seen a
There are
lot of
certain
cases
circumstances where you have multiple trusts.
where you've got second marriages, and they want to keep it
Mhm.
their assets completely separate, but they could also do marital trust and combine assets. And yeah, it's a good question, Molly. It really depends on your situation. Oh, Russ, it's good to see you on. So if you have multiple investments, properties for protection, should I have an irrevocable trust for each? Is there a limit? What's reasonable?
Typically, no. So with the if you're trying to use an irrevocable trust for asset protection, you're segregating liabilities. So you've got to identify what is the high liability versus what is the low liability, right? Um, because the trust only protects from outside creditors. So typically, if you've got stocks, bonds, even real estate, if it's a lower liability type real estate, you're all going to put that into the irrevocable trust, and then you're going to have the other assets that are high liability outside of it. Now, you could do multiple trusts, irrevocable trusts, but it's just going to add to the complexity of making sure everything's administered right and that money is going the correct way, or is going to the right trust for this asset versus this asset. I would say if you want a great asset protection plan, I'll give you one, but it's going to cost you $100,000 a year to upkeep, right? Nobody's been able to get into it, but is it really worth that? So you got to figure out, okay, what's my balance? How can I get good asset protection, but not have it be so overbearing that I can't actually upkeep it? So for most people, one irrevocable trust is sufficient.
And so, Russ, we often will use LLCs to separate the assets, which everything then ties down into the trust, rather than using multiple trusts to separate the assets. Is that fair?
Correct.
Okay.
Yeah, for
Can you
most
only
people that
make
works just
one?
fine. So
Can you only make one child the beneficiary and not the other two?
now you can name as many beneficiaries as you want.
And
So
disregard as many and disinherit as many as you
yep,
want too. Okay.
yep. Or you can just skip the kids and go to the grandkids. So
There. Generation skipping. A bank safe deposit where the jewelry is kept, can that be put into a trust in New York, or would we name the individual assets?
no, you need to actually put the account. Well, what you're going to do is you're going to have to actually name the successor trustee as an authorized opener on the account, so that person is so they don't have to have a key to it, and you can let them know once something's happened to you where to get the key. But if they went into the bank with the key and they weren't an authorized opener, the bank wouldn't let them in. So you've got to name the trustee as an authorized opener on that safety deposit box.
That would be one of the powers that the trustee or the successor trustee has
Mm,
to have. But the individual
right.
assets that are of value, do they have to be named in the trust?
No, they're just going to be personal assets. Typically, we just have a general assignment or transfer of personal property into the trust. So you
Would
don't
it
have to
matter
list
the
it out all
value?
specifically. Nope.
If I got a lot of stuff in there and it's a big safety deposit box, it doesn't matter.
I mean, you may want to make an inventory of it and make sure that other people have it in case you're worried about your trustee stealing it. Uh, but legally speaking, no, it doesn't matter what the value is. If it's personal property, it just goes into the trust automatically.
Okay, great. My husband did not have a will or a trust. His bank accounts, 401k are all frozen. How do I get them as his wife?
So if on the 401k, hopefully he has you named as a beneficiary. So you should be able to contact 401k company, provided them with a copy of the certificate and your ID showing that you're the named beneficiary, and you should be able to get into that one. Bank accounts, if it wasn't a joint account, um, you may have to go through probate to be able to get access to those bank accounts.
What do we do when the trust is in mom and dad's name, dad dies? Can mom make changes to the trust? I think you've answered that, but let's go
Yeah.
over that one more time.
Yeah. So it depends on the term of the trust. If it says mom can make change, if it says the surviving spouse can make changes to the trust after one spouse passes away, then yes, she can make changes to it. If it says she can't, or it says it becomes irrevocable upon the death of the first spouse, then she would not be able to make changes to it.
Okay. Molly's talking about restatement of a trust. Can you change a beneficiary? Does it have to be notarized? And because it's a revocable living trust, you can change it, you can amend it. Does it have to be named in the trust to do that, or can we add an appendix to the trust, or how do we really add a beneficiary to a trust?
So if it's a revocable trust, you can make changes to it at any time. Usually it's done through an amendment. So it's a separate, don't, one rule of thumb, don't ever write in your trust or your wills that will invalidate your trust and will. Like handwrite in it and say, I don't want this person in here anymore, and I'm going to put the other person in here. Okay, don't do that. It's a separate document that says I name, I'm changing this section of my trust, the whatever the benefit where the beneficiaries are, and it now reads as, and then you put in the new language. And saying my beneficiaries are now X, Y, and Z. They get distributions under these terms, and then you attach that to the original trust document. The
Okay.
other option is to do a restatement of trust where you rewrite the entire trust document. You keep the original name and the original date for the old trust, but rewrite it with all the new terms that you want, and then you sign it. And yes, it has to be notarized. And then you replay the document with that new one.
Great. Okay, Katrina is asking a really good question. Can beneficiary be prop can beneficiary keep property if there's a mortgage and keep paying on the house after mom and dad die, or do they have to refinance?
So there's the letter of the law,
Yep, yep.
and then there's what I've actually done. Um, so
Mom
the
and
technically,
the mortgage company isn't going to know mom and dad die unless you tell them, right?
yep. So under the terms of the mortgage, the person who guarantees the loan die, that is an acceleration event. They can require the refinancing at that time, but you are under no legal obligation to inform the lender that they died. And so I just tell the people, just keep making the payment. Don't tell them, and just let it keep going until they decide to actually try. And I mean, sometimes they actually figure it out, but it may take a couple of years.
Yeah, they guaranteed the note, and it's a personal promise to pay, and they're not there. And but my experience is, as long as the mortgage company keeps getting the monthly payment, they don't. I'm sure they care, but they don't know.
Yep.
If I have a trust set up years ago, do I need to make changes? Do I go through an attorney to change it?
It just depends on if you want to change who your successor trustees are or who your beneficiaries are going to be. I mean, honestly, I've seen trusts that are 40 years old and they're just fine. You know, mom and dad set it up at the time when they were in their 40s, and now they're in their 80s, and things haven't changed. The same kid is going to be the successor trustee. All kids are the beneficiaries. Um, Trust law is not a very dynamic part of the law. It doesn't change a lot. The only thing that changes from year to year is how they're taxed, right? How the estate tax works, things like that. But revocable trusts aren't set up in a way to really deal with estate taxes. So unless you have changes who like I said, the beneficiaries or the trustees are going to be, it, it can work just fine. Now, if you want to make those changes, typically you're going to work with an attorney.
Now, Noel, let me add something to that because in 2005, right around that is when HIPAA came into play. And if you've got powers of attorney that were created before that as part of your trust, what might happen is, let's say I gave John a power of attorney, but he can't get the medical records to determine that I'm incapacitated, and so his powers never kick in because he can't get the medical records. And so 2005 was a critical date for me. If your trust was created before that, it probably ought to be looked at to make sure that those powers, the springing powers of attorney never spring into action if John can't get to the records to get to them. Any thoughts on
Yep.
that, John?
So powers of attorney should be updated about 3 to 5 years.
Good.
If you have a springing power of attorney and it's 10 years old and it's never been used, and then something happens to you and I go into the bank to try and use this power of attorney, they actually will deny it if it's that old. So three
Okay.
to 5 years, it's always a good idea to update or sign new powers of attorney, but the trust itself should be okay.
Okay. Was there anything in 2005 when they changed the estate taxes that really will affect most people? I know there's portability clauses and a lot of the reasons for an AB marital trust, and maybe for large estates, but for the average person, probably not. Is that right?
Yeah, I mean the biggest change was the portability and the AB splits. A lot of older trusts do have those AB split trusts. You probably want to have those updated, although I mean I have worked around them. There are workarounds with them after one spouse passes away. It is a little bit more complicated to deal with. So if you do have an AB split trust where the trust splits in two upon the death of the first spouse, um, that was pre 2005, that may want to be updated.
Yeah.
But those are,
All right.
like I said, those are usually more higher valued as clients. So
Hey,
And would you,
Don, John, I did put the link there for because you got 76 questions to go right now. So just FYI, people are asking a lot of questions, and I put the link in there if they want to follow up with you, John. I did put that link in there. It should go directly to you
okay.
guys if you need a consult.
John, did you finish all your slides, by the way?
Um, no,
Is there
there was just a couple more, but I guess
is there
they're
a
more
call to action slide at the end if they
theoretical.
want to consult, or what do they do if they want more than we can get to tonight?
Yeah, so there's that link that you can go to set up a free consultation. It'll be with one of our advisors who can, talk you through pros and cons of estate planning, how we can help you if you are needing help with estate planning. And so that's a free consultation that you can do with Anderson if you do need more help with this or you want to look into it further.
Okay, great. All right, we are going to go a little bit faster, and students, we're going to close right at the top. To be respectful of John's time, we're going to close at the top of the hour, so we're going to go a little faster. Okay, should an
Okay.
attorney draft the instructions of the trust, or is it safe to do so on my own? What are the requirements of a valid trust?
So the trust document usually needs to be drafted by an attorney because there's a lot of pitfalls that you can fall into. Because our trust is about 70, 80 pages long, and a lot of it is pretty standardized language, but a lot of it is covering the what ifs, right? We've been through this a lot. We've seen a lot of different situations, and every time we see something that's unique, our document grows a couple pages, right? Because we think about, oh, we didn't think about that situation. Now we got to address it into the trust. So it's good to work with an attorney, make sure you have all the different possibilities covered within your trust. Now, a lot of what you can do alongside of a trust is what we call like a letter of wishes or instructions to your trustees, where you can tell them what you want it to look like, right? Because a lot of times the trustee has some discretion within the trust, like how to invest assets in the trust, how to take care of the needs of the kids, and you can direct the trustee on how to use their discretion within the trust separately from the actual trust document. And you can do whatever you want in that. That's something that I encourage people to write separate from the actual trust document.
So Santana, anything you can put into writing could be put into a trust, is my understanding, but that it has to be so clear that nobody can possibly mess it up. So my advice has always been clarify exactly what you want, give it to the attorney, and let him and add in the proper language into it, so that I don't know. I've seen so many fights and stuff over. I just don't like doing it. Okay. Can the trustee or the beneficiary be a non-US citizen? We've talked about that. Non-US residents. I think we've already talked about this.
Yeah,
Okay.
the beneficiaries can, trustees technically can, but it's not usually a good idea. If you can get someone in the U.S., someone in the U.S. is a trustee.
Can you discuss how to fund the trust? Discuss how assets should or not be placed into an irrevocable trust and the rationale.
So there's three main categories of assets that need to be funded into a trust. Yeah, real estate, businesses that you own, and personal bank or brokerage accounts. Like with the real estate, it's through a deed. So you have a deed from from you personally into the name of the trust, right? This is only if the real estate is in your personal name. Now, if you have it in a business, we don't deed that property into the trust. We transfer the business into the trust. That's done through an assignment of interest. It's an internal company record. We just have a 2-page form for it. It just says, I transfer my interest in XYZ company to my trust, sign it, you're good. The final one is bank and brokerage accounts. Like I said before, the easiest way to do this with most banks is to name the trust as a POD, a payable on death beneficiary. So you keep the account in your personal name while you're alive, and then on the bank records, it says when this person dies, it goes into this trust.
Okay. Don't put IRAs or pension plans into a trust. The IRAs are a trust. There's beneficiaries. They fall under trust rules. Bank accounts you would put into a trust, but we can't. The general rule, I believe, John, is that a trust can't own a trust. It can be a beneficiary of another trust, but it can feed in. But we don't have IRAs owned by your revocable trust.
No, that would create huge tax issues if you try to transfer an IRA into a trust while you're alive. Now, the trust can be the beneficiary of your IRA after you pass away.
In fact, that's common. For me, my wife, I guess I'm technically the beneficiary of my IRA. It was set up for my benefit. My wife's the contingent beneficiary, but my living trust would be the second contingent. Did I say that right?
Yeah. Okay. Yeah, that's typically the recommendation. Spouse first, because there's tax savings there, and then trust secondary.
Should life insurance policies and 529 plans be transferred into the trust?
Life insurance, typically you're just going to name the trust as the beneficiary of the life insurance policy. 529 plans, you would name, usually you're going to transfer the trust over as the controller of the 529 plan.
Okay. And if my kids were little, I might dump my life insurance policy into the trust. But if the kids are
even
older,
if your kids are older, I still recommend having the life insurance
there
as the
go.
trust. Yeah, because the life insurance provides liquidity, right? And the trust is paying for the debts and the taxes. So we don't want to have to liquidate real estate and stocks and things like that to have to pay those. If you have a life insurance policy just feeding straight into the trust, they've got instant liquidity and they can pay off all those things.
How do you know the trustee will execute accordingly? Because you're going to haunt them from the grave if they don't. Well,
yeah, like I said, most important decision you're making is that trustee. You better trust them. or you name, like we said, name co-trustees so that they're hopefully with two of them there, they can be a little bit more honest.
Is it true when we set up a trust for our property, it can save on taxes? Something to do with the step up?
A trust in itself doesn't necessarily change anything there. Step up in basis is based off of just inheriting an asset, whether the asset is subject to the estate tax. So that doesn't matter if it goes through a trust or a will or intestate succession. It's all the same. So it doesn't really change anything with step up in basis. A trust can help if you live in with state taxes. It can help reduce those types of taxes.
Okay. Income tax brackets in a trust versus individual. The trust is a disregarded entity, so it has no tax impact.
So a revocable trust, yes. You have 3 different tax classifications for trusts. Have a grantor trust, which is a revocable trust. As the grantor pay the taxes, it does get a tax ID number. It just automatically flows to you personally. After you die, then it can become either a simple or a complex trust. A simple trust is where the income from the trust flows through to the beneficiaries. They get a K1, just like a partnership or an S corp, and then they report that K1 on their personal tax return and pay the taxes. Or you have it as a complex trust where the trust pays the taxes on a 1041 on its own tax return. That is the one you want to avoid, because the tax rate at which trusts pay taxes is much higher than a personal tax rate.
Okay. How is the trust administered if the beneficiary is not a U.S. citizen and has never lived in the U.S.?
As long as you have the trustee who's here in the United States, they can administer the assets in the trust, because the assets are always titled under the trust. And then as needed, they can make distributions or transfers to the beneficiary who may be outside of the United States. Now,
Is there a problem with repatriating money in and out of the U.S.?
Yeah, I mean, there's logistical issues with that, right? But it can be done. So.
Okay, got it. Okay. What is a marital trust? How does it work?
A marital trust is typically when we're talking about when the first spouse passes away. At least within our trust, you have the option of splitting the trust into two pieces. You don't have to if you don't want to, but you can. And one portion goes to the marital trust, one portion goes to the non-marital trust. This is typically done for asset protection purposes or for state estate tax purposes.
Or second marriages.
Yeah, or second marriages or issues like that. So when you're splitting it, you have one portion that's still a revocable trust and one portion that goes technically into an irrevocable trust. So you have the marital trust is usually the revocable portion. The non-marital share goes to the irrevocable portion.
Okay. Kay is asking about, what if I have nothing at all? Do I still need a will? Will you talk a little bit about state thresholds? And because really small estates typically don't go through probate, because the probate court says unless there's a fight, just handle it. But those thresholds vary from $5,000 up to $200,000, depending on the state you live in. Will you address what if we just don't have anything? Do we still need a will?
Yeah, so there are what we call small estate procedures that you can go through in the various different states. The limit for that varies. Like you said, it can be up to $200,000 or as low as $5,000. If the assets that you have are below that limit, then you don't have to go through probate. It's an affidavit process. Usually, your whoever is going to be taking control of your assets just simply files an affidavit to take control of your estate. But if you're over that limit, or if you have real estate will always kick you into probate. Doesn't matter the value. Now, the best type of estate planning is that you use your last quarter in a payphone to call the mortuary to come and pick you up. So then there's nothing to fight over. If that's your situation, great. Then you don't need a will or a trust. But if you're over the state limit, you can look up, small estate, for just Google whatever state you're in, and it'll tell you what the limit is. Or if you have any type of real estate, then you're going to have to go through probate. Now, I have used trusts in connection with the small estate process. Like I had a client, he was worth 20 million plus. Okay. We had almost all of his assets in the trust. His wife passed away, and she had a small retirement account that was less than the limit was in California. Because everything else was in the trust and wasn't subject to estate tax, we could actually transfer that account using the small estate process affidavit without going through probate into his trust very easily, very simply. So
now, John, I've often heard attorneys say that they always like one small asset to go through probate. That way it ceases all creditors' claims against the estate. So what are your thoughts about taking a small bank account or maybe a vehicle, running it through probate, putting everything else into the trust, but running one asset through? What are your thoughts on that?
I have done that before, but it's usually I only do that if I know there is a creditor that we have to worry about.
Which leads to Molly's question: does a trust protect the asset from the creditors, from the grantor's creditors, or from beneficiaries' creditors?
No, it doesn't it doesn't, a revocable trust does not protect against the grantor's creditors, but it will protect against the beneficiary's creditors after you pass away.
That's what the spendthrift clauses in the trust are meant for. Is that correct?
Correct.
Okay, got it. If you can make updates to the trust, do you have to redo the entire trust, or can you simply amend it to give when you set up a new account? I think you've answered that.
Yeah, so you can just do a new document if you've changed who your successor trustees are and you've got, your trust as a POD with a bank. Usually you need to go and update that information with the bank records so that they can know who to expect to come in after you pass away.
Okay. I currently have a will written 10 years ago. If I open a trust, how do I officially make sure nothing in the will is valid? Because we're going to fund the assets into the trust. The will won't control it. The trust will.
Yeah, so trust control any assets that are titled under it. Also, whenever we do a trust, we do a pour over will along with it. That pour over will nullifies any prior wills that you have done. So you have a will that refers to your trust, and that basically takes care of that. So
Yeah, when you do the pour over will, you remember last will and testament, I being of sound state and mind and body and nullifies. It's the last will, and it nullifies everything else you've done. And so, yeah, it's kind of automatic that way. Is it true that you can also protect assets from divorce? What I mean is, if I have assets and give them to my sons via trust, my assets will not go to his spouse. So you're worried about divorcing your kids getting divorced. Can you put in spendthrift clauses to prevent spouses of your children from getting assets?
yes, it does protect against that. So when you receive an inheritance, it is classified as separate property.
Even in community property states.
Even in community property states. So if I got $100,000 from my parents after they passed away, and I put that in a bank account just for me, and I just left it there, that wouldn't even be subject to the divorce.
As long as we don't commingle assets, and yeah, that's when it gets ugly.
Yeah. So if you keep it separate, that's good. The problem is most people commingle it, and it's very easy to commingle assets. But if we keep it in so if it's in your trust still, then definitely that hasn't been commingled. That's separate. So it will not be subject to the divorce.
Okay. So students, we are not going to get to every question. I'm sorry. Let's, in the chat screen, there's a link to a free consult with somebody from Anderson to be able to go through some of these questions. Our hotline is always open. If you, well, okay, not at midnight. We don't do that, but you're welcome to call. But to talk to the attorneys, I would recommend you click on that. Let's go 3 more questions, and then let's wrap it up for the night. John, thank you for your time. We could go all night. And does an irrevocable trust need an EIN number to report to the IRS?
While you're alive, for a revocable trust, no, it actually uses your Social Security number. After you pass away, though, then it does get an EIN number to report to the IRS.
When it turns irrevocable, then we need an EIN number. And depending on if there's any activity, then it might have to file a tax return.
Correct.
If you have LLCs, do you do the paperwork to have the LLC under the living trust? How do you tie the LLCs, your ownership in the LLC, and how do we tie that down to the trust so that when you die, your interest doesn't go through probate?
Yeah, so you transfer the interest of the LLC through an assignment. So it's just a internal company record that says the interest, John's interest in this LLC is transferred to the John Anderson Living Trust. And you sign it, put that in your company records. Usually you'll have meeting minutes that go along with that saying that you authorize the transfer. But it doesn't have to be registered or filed anywhere. It's internal to the company. Now, most people will think, well, I need to create an LLC. see, I'm going to have to do it in the name of my trust. No, actually, we don't recommend you do it in the name of your trust. It's if you're creating an LLC, create it in your own name if you're going to be having it in your trust, and then transfer it into the trust after you've created the LLC. Because when you go into the bank to open a bank account for that LLC and they see a trust as the owner, they're going to freak out and they're going to make you do all these extra steps to get that bank account open. But if they just see you as the owner initially, then you can get the account open fairly easily. And then you can just do that assignment, transferring it from you to your trust.
Perfect. Thank you. And I've seen multi-million-dollar corporations and LLCs when let's say a single member LLC, husband dies, the company is in his name. Who owns the LLC? His interest now. Well, it's going to go through probate to figure it out. And so, it's a great question. Thank you for asking it. How would you name the trustee as the beneficiary on life insurance? I think you answered that. And one more, can an individual create their own trust? And if so, once it's created, where do you take it to, or who do you file it with?
I mean, yes, you can create your own trust. You don't file it anywhere. A trust is a private document. You transfer assets into the name of the trust. So if you have a piece of property, you're going to deed that into that trust so that the trust is now listed as the owner. That is the only type of filing you would do, but the trust document itself is not filed or registered anywhere.
But I would make sure that the beneficiary has a copy, the successor trustee has a copy. We're not going to file it with any state agency. I love the little one or two page Cliff Note version called a certificate of trust. When you go down to the bank to transfer a property, you go to the county recorder, they're going to ask for the copy of the trust. You're going to tell them to eat dirt, just give them the certificate. That's all they need. You're not going to see my trust. There's the certificate. That's everything you need to know. And you don't file it with any agency. So please, students, there's nobody we trust more to be able to do your estate planning than Anderson. John runs the estate planning department. We so appreciate his time being on here. If you have questions, and I know you do, this opened up so many questions. We did answer more than we left open, but I know you've got questions. Thank you for your hearts and thumbs up and claps. John, those are directed to you. Thank you very much for that. And then we will cover this, Clint and I, on the next 3-day summit. Make sure you sign up for that. We're going to cover a lot of this same material, not as well as John did tonight, but we'll try to come pretty close. John, thank you for your time. We so appreciate it. Any closing remarks?
Let me throw one more thing in here. So we've got the link for the consultation if you want to talk to someone. Another thing we just recently put out is what's called an emergency binder. This is free. If you want to go to our website, you can click on there, download it. It's basically a way of organizing all of your documents, that you have, your trust, your powers of attorney, other things that you may have, and putting it all in one place so that if something happens, it can all be centrally kind of located. So this is just a free resource for anybody. You don't even have to be a client. But it's an option there. If you're looking into maybe getting a trust, this can be a good starting point to help you starting to get organized with your estate plan.
Cool. Great. Thank you for that gift. That's brilliant. All right, students. Thank you. It's really late on the East Coast. We appreciate you sticking with us. And John, we love your time. Thank you very much.
You're welcome.
Everyone, have a great night. Thank you for being here. Good night.